DS's continued motion regarding parenting time is Ruth is president of the court, represented by Attorney Dennis Reed. Mr. Hamill is present. He is in pro se. The court had an opportunity, was Wednesday?
Yes.
Wednesday, we had an opportunity to meet with the minor child. We will not mention the minor child's name. However, we had the opportunity to meet with the child, and a very bright child, by the way, both parents. Very articulate, smart young lady. In addition to that, well, is there anything further you wish to add, Mr. Hamill, regarding your motion regarding parenting?
No, Your Honor.
Mr. Reed, on behalf of your client.
I do, Judge. I want to tell the court that I initially just got involved in this case about a week ago, and so I've been working diligently to get up to speed in terms of what's going on here. I spoke with the front of the court this morning, and if the court will refer the motion for an investigation, their office will be happy to do that for us. What I'm finding out so far is that I'm asking the court to proceed very cautiously with this motion. We have an 11-year-old child here who, from what I'm hearing from witnesses, is having physical reactions to what the court has ordered in terms of visitation here. Twice in her life, two other occurrences, she's had panic attacks. First one occurred a few years ago when this gentleman was charged with physically another child of his. As the court's aware, you handled the sentencing. Child became aware of it somehow and was suffering panic attacks at that time. That subsided. Over the last...
Was that in the original pleadings? I don't recall anything.
Well, this is what I'm finding out and talking to witnesses, Judge.
Okay.
So this motion was filed.
Medical records pertaining to that?
That's what I'm getting into here, is one of the things I want to get into. This motion's been pending about a month, roughly. And in the last 3 weeks, she has been suffering panic attacks again, wanting to sleep with her mother. Last Saturday, you had the first supervised visit. The child was vomiting before she went. She's extremely stressed about this whole situation. Her grades have dropped. She was an AB student on the honor roll. And over the last month, her grades have dropped from A's and B's down to C's and D's. This is having a negative effect physically, emotionally upon this child. And normally I'd say, Judge, let's just enter counseling. But this sounds like, to me anyways, this is pretty serious. Now, Mr. Hamill had a court order, from what I've been able to find out, 8 years ago, what appears to be standard parenting, and never exercised it. His visitation with this child for the last 8 years has been haphazard. It's been mainly at family gatherings, or the child's been at another relative's home. He has stopped by and had brief contact with the child. That is the extent of his parenting time for the last 8 years. 2021, I understand this court suspended his parenting time completely. And even though it was suspended, he still had informal contact with his child. Usually when it was at another relative's home, he would stop by and say hello, and that was it. That's not my client's doing. That's not the child's doing. Mr. Hamill has waited all these years to finally file a motion to become a parent for this child. And now we're just supposed to throw this little girl into this mix and say, here. And she's having some bad reactions to this judge. Now, after hearing all of this from my client and witnesses, I have suggested that the child start counseling at Thumb Psychological Services in Cass City. There was a counselor over there I ran into this summer. It's the only time I've ever been involved with that counselor. And it was a similar case to this that we had down in Sanilac County. And I thought she did an exceptional job. She has almost 40 years experience counseling children that are traumatized. And I'm thinking that if we can get in to see her, that would be the ideal solution here to help this little girl with what's going on. If the court is going to continue parenting time, I think it should not continue at this point in time and should continue suspended until we can get to the bottom of what's going on here. What I would ask is that the court refer the matter to the front of the court for an investigation. Give us some time here to get this child into counseling, find out what is going on. Mother has affirmed to me this child has no other diagnosed emotional problems. And this is alarming when you think about it, that if she has no other problems in her life and all of a sudden now she is even afraid to see her father's vehicle drive down the road. That's how scared she is. She's scared of him. Now, what we're asking the court to do is, if you do order continued supervised parenting time is that we make some changes here. First, that dad must be present for the entire visit. This isn't grandparent visitation. This is parent visitation. And so if he's going to force himself basically upon this child on a regular scheduled visitation plan, then he needs to be present for the entire visit, including transportation. If he has to leave or he cannot attend that day, then the visitation ends or doesn't occur. Secondly, we understand there's some daily drinking going on, and there's to be no alcohol consumed immediately prior to nor during any visit to this court might order. That includes the supervisor. Any conversations, any communications involving the child are to occur between mother and father. No third-party intermediaries here. And I know the court has a long history with app close. Presumably both parties can use that. I would suggest that is the media that they are able to communicate with. And of course, he has to be present during any transportation of the minor child. But we would like to see the visitation just suspended temporarily until we can get this child into some counseling and see what's going on here.
All right, thank you. Graham, any comments?
I planned on getting an attorney for myself, which I already called, and she couldn't get me in until Monday morning.
Okay. All right, but no other comment?
Nope.
Okay. All right, well, when we meet with a child, a friend of the court and I sit down with the child, there are no questions that try to suggest an answer. We just get to the meat and potatoes of it as to what's going on. And we also make a promise to the child or children that anything shared will not be shared in open court because we don't want to put the child against either parent. Mr. Holwick and I met with the child this past Wednesday, and it appeared to the court that this child knew more about the case than I did. In other words, this child appears to know motion dates, know arguments, know what's going on with the status of the case. And it also appeared to the court, and Mr. Holwick can speak for himself, but it appeared to the court that this child was coached. And I'm not going to go into what the child said, but that was alarming to me. To hear today that the child is experiencing trauma and is suffering grade-wise, is afraid of father, has all these issues, is also news to the court today. I'm not questioning it. I'm not saying it's not happening, but it's just news to the court today. I don't recall the prior pleadings, and I'm not going to go into what the child said. But one thing I did believe after speaking with the child, and I think Mr. Holwick agrees, he can speak for himself, but this child does need some form of counseling, whether it's family counseling, individual counseling. I'm not sure. And so I hear father now wishes to seek an attorney, and that's probably a very good idea. Court is going to order on an interim basis that, and do you have any objection to counseling, by the way, for the child, sir?
No, what I mean. I don't really want to say anything, to be honest with you.
Okay.
Okay. I think the kid needs her dad. Other than that, nope, I'm just gonna,
Okay.
whatever you all think.
All right. I agree with the counseling. If it's some counseling, that's fine. But any and all documentation, reporting, father is equally entitled. He has joint legal custody. And the counseling has to be for the child. In other words, get information from the child only. Obviously, parents have to supplement that information, but fathers to equally supplement whatever information he may have as well for this counseling. Regarding visits at this point, do you have an idea when you may be able to retain this attorney, sir?
Monday is
the earliest?
Yeah.
Okay. We will set it for a status conference. We're here next Friday.
Yes.
We'll just set it for a status conference and see where we're at. I will suspend the parenting time this weekend. Next Friday, we'll have a status conference to see, can the child meet with the counselor before Friday?
We're working on it, Judge. I can't, I don't want to say definitely because obviously it's the scheduling of other people we're dealing with here.
If I would like, and it could be by way of a Zoom visit, if the other attorney's involved or father is still representing himself, I need to know if the child met with the therapist, counselor, and if she has any recommendation as to whether or not parenting time should continue.
We'll do our very best, Judge. That's all I can tell you on that issue.
Regarding all the other issues, except for a friend of the court investigation, the court will take that matter under advisement. The court finds that there is proper cause of change in circumstance. Actually, the court finds change in circumstance here, and as a result, a friend of the court investigation regarding parenting time will be ordered.
Will be ordered, Judge.
Will be ordered.
Thank you.
Mr. Reed, please prepare the order.
Shall. What
And
time will that be next week, Judge?
9 a.m.
9.
And in the meantime, obviously, Dad hasn't seen, or maybe you've seen probably the weekend. I'm not sure what happened. Visits, but I'm going to stress there's to be no. This child needs to be 11. This child doesn't need to be inundated with adult information. And everything you tell this child should be along the lines of, we're just here to take care of you, we're here to guide you. Any comments regarding, well, how this case is going, or what Dad did, or what Mom did, and all that, it's not proper for this child. We want the child to speak for herself.
Yeah, if I may, when I had her on that Saturday, all we did was went to my daughter's second birthday party.
Okay.
That's
Very good. All right, we'll do a status conference next Friday, see how things are going.
Thank you very much, Judge.
Thank you. Going to give you the Ruth versus Ethan Hamill. It's time of day set for status conference. Parties are present. Appearing on behalf of the plaintiff, excuse me, is Attorney Dennis W. Reed. Hamilton pro se. Before we proceed to this matter, the court was advised by court administrator that there may have been a request, not may, there was a request potentially for an adjournment in this matter, based upon, I believe, Mr. Hamill thinking about counsel, seeking counsel. I asked Mr. Reed what the status was, and he was going to address it on the record. Is that a fair assessment of our conversation, Mr. Reed?
Yes.
Mr. Hamill, do you agree?
yes, sir.
Oh, Mr. Reed, go ahead.
Thank you, Your Honor. Your Honor, today was scheduled for the status conference only. This isn't the motion. The motion was actually, I submitted an order. I assume it's been signed, but that motion for custody and visitation, visitation was referred already to the Huron County Front of the Court's office for an investigation recommendation. So that issue's moved on from where we are today. Today's a status conference, and there was 2 issues that were brought up last Friday that I think the court wanted updates on today. The first being Mr. Hamill's request to obtain an attorney. And I had understood at the time that he had an appointment that I believe he did keep on Monday with a local attorney. And then the second issue was the counseling of the minor child. We initially had thought some area counseling in Cass City would be a good choice. My client Friday afternoon got a hold of them, and they are simply booked solid, and there was no way we were going to get in to see them. So went with our second choice, which was List Psychological here in Bad Axe. That was successful, but they weren't answering their phone on Friday for some reason, and so my client had to wait until Monday, this past Monday, to actually talk to somebody there. And fortunately, she was able to get the child in for her first appointment yesterday. All indications are that it went very well. The child opened up to the counselor, and apparently they had a very good session. The counselor wishes to see this child weekly, and so there's at least for the next 3 weeks there are scheduled appointments for her to go to List Psychological. The counselor's name there is Logan. So that part of the case is moving on as we had hoped it would. On Wednesday, Mr. Hamill called me at the office, had a very friendly conversation with him, and he explained the difficulties he's having in trying to find an attorney. I gave him some suggestions on perhaps where he might look for an attorney. And all indications to me is that he was going to try to do that. So what I'd like to see the court to do today, now that you're kind of up to speed on where things are at this point, is that we just continue things as they are. Mr. Hamel can proceed to try to find counsel. He may still run into problems, I don't know. And then once there is an attorney on board, perhaps we then can come back to the court at that point in time. Because continuing to set status conference hearings seems, I don't want to say a waste of time, but it seems like it's unnecessary at this point
It's a
in
little
time.
expensive too.
Yes, and the travel time. And then, as I indicated, I don't mind coming up here, but I just wanted to bring the court up to speed that things are progressing. And I just want to continue things as they are until this gentleman can get an attorney on board, and then we can address matters further at that point in time.
Mr. Hamel, do you have any response?
Not really. I did find an attorney I got an appointment with on this coming Tuesday.
Good. What do you think of the request by counsel that's just keeping it status quo until you get your attorney fully on board?
I agree.
There it is. But that would require then, in the event that counsel is retained, that if there's any issue, counsel would file a motion on behalf of Mr. Hamel.
That's what I'm anticipating.
You understand that, Mr. Hamel?
Not really.
In other words, we're just staying status quo right now at this point, and until you motion the court for what you're asking for with your attorney, it just remains status quo.
Right.
So the next step would be yours if you wish to do that. Does that make sense?
Yeah.
Okay, and you're in agreement with that?
Yep.
I don't think we need an order.
I don't believe so either, Judge. Thank you.
Okay.
Very good.
Thank you all. Appreciate it. That'll be all. That's forward. It's time today set for show cause and a motion order to show cause for contempt has been filed. In this case by Mitchell Holdwicks, dated September 30th, 2024. Mr. Emmerich is present. He's the subject of this motion. Mr. Emmerich, would you please raise your right hand?
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
Mr. Emmerich, your name is Randy J. Emmerich, correct?
Yes, yes.
Did you receive a copy of the motion order for show cause in this matter?
I think I did. I guess I really didn't pay much attention to it, to be honest.
It was mailed October 1st. Do you want me to read it into the record?
If you can, yes.
Sure, I'm glad to. The motion indicates Randy Jack Emmerich was ordered to pay support. The office of the friend of the court has reviewed the records and determined the past due support amount on September 30, 2024 at $800, which exceeds the statutory amount allowed, that is. Mr. Holdwick requests the court issue an order to show cause why the payer named above should not be found in contempt for failure to comply with the court's order. Mr. Holdwick dated this September 30th. And obviously that's why Mr. Emmerich is here today. Do you understand the motion, Doctor?
Yeah.
Okay, thank you. Mr. Holdwick, do you want to supplement this?
Your Honor, currently this account is charging $800 a month in spousal support. The account is $1,600 in arrears. Mr. Emmerich was in my office for a show cause back on July 17th, 2024. He did, as a state, he did appear. That day he made a $2,242 payment to bring the account current. The show cause was dismissed. The stated that payments would be made monthly. No payments were made for the month of August or September. So the show cause was scheduled to be brought before the court as this is a spousal support case. I do see that for the month of October, Mr. Emmerich did pay $800, just the base spousal support amount. So the account still sits at a arrears of $1,600.
And you're requesting
Because this is a spousal support case and is a DO, it was brought before the court for show cause for non-payment. Regarding, it's not 4D service, so right brought before the court.
Okay. All right, Mr. Emmerich, can you tell the court what's going on here?
Basically, I don't make the money that I made when this was all wrote up, and I've been making payments whenever I can. I just made one 2 days ago or 3 days ago. I don't make the money I get, so I can't necessarily afford it.
This is a consent judgment of divorce, though, which you agreed to.
Well, I didn't really agree to it. My lawyer basically agreed to it. Yes, I did sign my name to everything, and but that's when I was working in the city. And because of all this, basically because we had 6 months to take care of the divorce, but my lawyer and her lawyer decided to take the last 6 days of the 6 months to take care of everything. I was up north working on the Sioux Locks, and I got caught 4 times talking on the phone to my lawyer about all this mumbo jumbo. And basically I laid off for it. So I lost my job up there over the whole thing. So I've been doing what I can, borrowing money where I can, doing this. The $2,200 I paid the last time I was here was borrowed from my mother. There was another dime there. I think there was $2,400 borrowed from my mother. I helped the guy build a pole shed. That money in turn went all to her. And that just isn't out there anymore. I got a motion here that I've got kind of half filled out, that I was going to see if I could get this taken care of, like not have to do it, pay anymore, because I can't afford it. Last month, my bills were $4,398. And the last 4 paychecks that I have amounted to $4,342.62. So I'm just $40-some or $50-some behind right there already. That's not even paying the $800.
Mr. Emmerich, the problem though is you did agree to this, and the judgment that the court entered in this case, and I'll read it, it's hereby further ordered and adjudged that defendant Randy J. Emmerich shall pay to the plaintiff Norma L. Emmerich through the Michigan State Disbursement Unit non-modifiable spousal support in the amount of $800 per month commencing August 1, 2023 and ending December 31, 2034. Non-modifiable. This was agreed to.
You know what I was told, Judge? I was told to sit over there and say nothing by my lawyer. Say nothing. When you asked if I had any questions, I had all kinds of questions, but I was told to not say a word. That's why I don't have nobody here with me today, because I'm going to say what's necessary to be said.
Oh, I understand that, but that's why I always ask those questions. Is there anything else? And the reason the court does that is I don't want situations like this to happen. Mr. Holden, or Ms. Schultz, any comments from the front of the court regarding this?
No, Your Honor, we are getting complaints about the spousal support not being paid, so we brought it for enforcement.
Yeah.
It's not a 4D function, so we're bringing it to the court's attention.
I thought it was read to me that it is modifiable on the back sheet of whatever forms Mr. Holdick has.
The Uniform Child Support Order form, Your Honor, on the last paragraph does provide,
For child support.
it provides that the spousal support is modifiable only as it relates to the defendant paying the plaintiff. You can pay directly or you can pay through the Michigan State Disbursement. That is how I understand that provision.
And that's why they put non-modifiable in the consent judgment. Mr. Emmerich, you can bring your motion that's obviously can't be heard today because the other party needs to be here. But at the end of the day, I have to enforce what's written. I have no other choice.
Okay, then can you explain to me how I'm supposed to pay this? I lost my job because of this up in the Sulaks. I lost my job over this because I was trying to deal with this. And basically I told her, whatever has to be done so I can keep my job. I can't halfway home to meet with these people. And they said, oh, you might as well turn around and go back because Tammy Salen, she's sick today, so we can't do anything. So halfway, I gotta go back up to the Sulaks. A couple days later, can you come back down? If I have to, yeah, but I can't be taking off all these days. So I'd just like to know how I'm supposed to pay this if it can't be modified.
Well,
It's I could go into all kinds of things over the last 32 years of my marriage, if necessary, but obviously it doesn't. I mean, I gotta forward it, do this motion in hopes that something can happen, but.
Mr. Emmerich, let me be clear. I'm not telling you not to file your motion. I'm just telling you what's before the court right now. And what's before the court right now is a consent judgment for divorce, which means that both parties consented to it under oath. And for me to disturb that today without a motion, one would not be proper because it was already entered and these judgments wouldn't be worth the paper they're written on. So I encourage you to file your motion. That can be addressed, but there are complaints from the other side that they want their money. Can you set up a payment plan? Can you set something up at least so that there's something being received?
Yeah, I just paid it, like I say, 200, I think it was $200. 2 days ago, or maybe 3 days ago. And if I read the thing right, I think you're supposed to do it 5 or 6 days before, and it just didn't happen. But I just paid her $200 more too, so.
When did you do that, sir?
2 days ago,
2 days
2
ago?
or 3 days ago.
Do you have a payment plan proposal you can put?
I don't have a payment plan. My payment plan is that I don't make enough in 4 weeks to take care of my bills because I got all the bills over this whole thing. You got a house, I got a house, I got a piece of property, she got a piece of property, but Randy got all the bills too. That she agreed to and signed to. I know it's really, it's upsetting to me on how the thing went with my lawyer and how I agreed to it just to keep my job up there, and it did happen, so here I am.
So do you have income anymore? Do you have?
Yes, I'm working for, I haul milk for,
You don't have to say who, I just want
Yeah.
to know that you have a job.
Yes.
Okay. Well, the obligation's still out there. And what I will require is, what are your working hours?
From 8 to 10, 12, 11 hours a day.
You do get a lunch though?
Yeah, basically I get a lunch. I drive truck, so,
Right.
but yeah, I get, when I'm waiting to unload or whatever, yeah.
Okay. What I'm going to have you do is set up another meeting with Mr. Holdwick. It can be by phone to discuss potential payment plan. And then in the interim, you want to file your motion, please do so. The court will hear it and we'll address it at that time. I'm not hearing anything regarding a payment plan at this point, and I'm not going to install this thing and try and get blood out of a stone. I can't do that at this point.
And I can't.
But you have the obligation, you have to pay it at this point, unless something changes. That's all I can do.
So when can this meeting be?
You just give Mr. Holdwick a call when
Okay.
you're available. I'd like you to set it up within the next 7 days. Not to have the meeting within 7 days, but at least to set up a meeting within 7 days. So in other
If he's
words,
available after, I can do it today. If not, that's fine too. I can come in tomorrow, the next day, whatever. Or the next next week.
If he wants to wait, I can't, till our docket's done.
okay, let's do it today. We'll try that. Okay, that'll be all. Thank you.
Okay.
Matters, I should state for the record, that matters still remain under advisement by the court. We'll set up that meeting, see how things go, and we'll address it. Thank you, Mr. Osborne.
Just, I guess.
These are petitioners' motions to extend personal protection orders. The petitioners are present, respondent is present as well. Would you all please raise your right hand?
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God? Yes, I do.
Thank you. You may put your hands down. Ms. Ruth Osborne, do you have legal capacity on behalf of Vivian Lee Osborne?
I do. I have guardianship of Vivian Osborne, and the paperwork has been submitted with the original PPO request.
Okay. You may proceed. You're requesting an extension. Go ahead for your reasons.
Yes, Your Honor. The original reasons for the
Well, where are the original?
Yes, okay.
Change over
So
here.
what has changed since our hearing in April is that Mr. Osborne has tried to find out what we're doing and where we're doing it from family members. Since he has stopped calling us, there have been some good improvements in mood stabilization for my mom, who has been diagnosed with Alzheimer's. And so not having contact with my dad, her husband, has been a thing that has been quite helpful. And she has mentioned in a large number of times throughout this whole process about how good it is to be living an hour and a half, hour to an hour and 15 minutes away from Mr. Osborne, so that he can't just drop by. She mentions often how she's so glad that he doesn't call her and that she doesn't have to talk to him. And again, back to when he was able to call her, every time he called or left a voicemail and we listened to those, she would get upset and would have panic attacks and agitation, and at times would throw her phone on the bed, or initially at the beginning of this, before we ever asked for a PPO, she had hit her head on a door frame in frustration and anger, and stating that she just everything is really bad for her in those moments. And so since there's been no contact with him, I don't see the physical reactions to it at all. If she has a moment where she's upset with life, it lasts for no more than 20 minutes instead of being hours long. It's a drastic difference to not have Mr. Osborne be a part of her life. And just honestly, Your Honor, every time we've come to this building since we've obtained the PPOs, Mr. Osborne feels the need to come up and talk to us, even though we have PPOs. We did it this morning before you ever entered the courthouse, and the whole time that we've had these proceedings, he keeps glancing over, and half of the time he's glaring. Whether it's at me or my mom, I wouldn't be able to tell because we were sitting right, in the same line of sight. So I had to keep moving my body so that he could not glare at either one of us and have upset my mom. Mr. Osborne also does not understand all of these proceedings, because he mentioned that he thinks he's getting her back today. He thinks he's coming to court to get mom back. He's confused. He's not thinking right. I'm sure he has read through the paperwork that was provided with my statement, Your Honor.
And I read it.
And you've read it.
Well, Ms. Osborne, I understand that. Tell me about your PPO.
My PPO, so for my own personal reasons for needing a PPO against my dad is because
Extending it because
extending the PPO, Your Honor, is because due to my training experience and my experiences with my dad, he's not good at letting things go. And so I'm already, even with a PPO, when I walk out of a door or step out of my car, or whenever we come over this way, I'm looking for his car. I'm looking to see if he has pulled up outside of my home because he's tired of dealing with all of this stuff. He has been holding a grudge and has been extremely angry and has had such hatred for me for so long. There's no way that this is going to go away. It's been 4.5 years, and it started with him 4.5 years ago threatening to kill me, and now he still held those angry feelings to an extreme, to the point where Judge Harrington commented on it in the last hearing we had. So Mr. Osborne is not going to let go of that, and I'm scared of him having the last moment where he's had enough, and he decides to come after me, because that would harm me. I'm not okay with that. Your Honor, I could easily, as a police officer, I can absolutely protect myself. I can protect my mom, but I shouldn't have to protect myself and my mom against my dad because of his anger issues. Thank you, Your Honor.
Mr. Osborne, your response, sir. You can be seated, sir.
Well, if you don't mind, I'd rather.
No, go ahead. Sure.
Better on the back. In the first place, I haven't asked anybody in the family what they're doing. That's a lie. I have been in contact with my family. I've got 5 grandchildren that love me, and they're angry with their dad, 3 of them, because of the PPO. They said this is just not right. Your dad has never been mean to anybody. In fact, I had 3 people lined up today to tell you that I'm not a mean person, that I'm a very easygoing person. One of them is the owner of Old Guy Tire Company. I think he owns Merit. And the other one is Jim McCollum, who's a friend of mine from Caseville. And the other one that was going to come, and I told her, don't worry about it because you've got too much to do, is Beth Ann Beachy, who owns Beachy's Restaurant in Lefties, and so on and so forth. And she always said, oh, you're such a beautiful man to me, because I have been nice to everybody that I meet, even including my daughter, who's a man hater. And I can tell you lots of things about what she has done over the years that are not good. My sister Lois wanted to have her come down to Pittsburgh and stay with her for 3 weeks. back when she was in eighth grade. And I said, yeah, that's fine.
Back when Ms. Osborne was in the 8th grade?
Yeah.
How many years ago are we talking here, sir?
Oh, a lot of years. That's beside the point. I want to get it point across to you.
Okay.
So I gave her permission. I said, if Ruth wants to, and Ruth said, yeah. Because Laura said, your daughter is so much fun. And she is. And I love her. I still love her, regardless of what she's done to me. But she went down there and her Lois's daughter, Kathy, who was a senior in high school, said, Mom, Aunt Ruth is an actress, a liar, and evil. And my sister Lois said, oh, Kathy, don't talk like that. Because Lois would not say anything like that. Say anything. And Kathy said, I'll never say another word, Mom, but I want you to watch what she does and watch what she says. 4 days later, they brought her back, drove all the way from Pittsburgh, Pennsylvania to Kalamazoo, Michigan, where we were living at that time. And she said she wasn't having a good time. Well, since all this happened, she said, now I'll tell you the truth. I was warned that she was a liar, she was evil, and an actress. And that's why I figured out we got 4 days and I couldn't take another minute of it.
Do you wish to call any of these witnesses, do you wish to call them?
If they'd like to, they've spent a lot of time here waiting. And I'm sorry.
Okay, well, it's up to you, sir. Do you wish?
Yeah.
Mr. Schmerich, would you please step up to the witness? We'll see. Okay, go ahead, sir.
When I first met Bill, when my choir was singing, I had a professional choir. And at TTLM, I heard Mr. Osborne sing, talking afterwards, and that began our friendship. We've been friends since then. I've been privy to some of the things that happened in their family. It makes me sad. Of course, Ruth was also in my choir, and the sides I see myself are not the sides that I'm hearing here, because I'm not privy to that side of it. Bill, did you have some questions on this?
Any questions?
No, all I want to know is, have you ever seen me be angry with anybody? I'm angry.
Angry, no, but just upset and mad because somebody said something that perhaps wasn't true, or felt like justice has been done. We've had out in and out as a conversation. We've had meals together.
But I treat people nicely.
The side I see.
Thank you, man. I appreciate that.
Ms. Osborne, do you have any questions?
I don't have any, Your Honor. Thank you.
You may sit down. Your next witness?
Okay, that's Jim McCollum.
Questions, sir?
How many years have I known you now through all with him?
After I first met Ron, was it all for him? When my late wife was singing with him. It's been quite a while. She's been gone almost 10 years, so probably 15 years.
So have you seen me mistreat anybody?
Oh, I haven't, no.
That's what I wanted to know, because I've had so many people say they would come, but they couldn't because they're working.
Do you have any other questions of this?
No. Thanks very much.
Ms. Osborne, do you have any questions?
I don't, thank you.
Mr. McCall, you may. Do you have any further proofs or any other arguments?
First place, she spent 33 years in the state police. About 3.5 years at each post before she hit and regretted the loss and leave. So she was at 9 different posts in those 33 years because she couldn't get along with the boss. The only time she did was in Bay City when her boss was a woman. The other ones were men. She married here in Bad Axe. We're at war all the time. She does not like men. She treats them well if they're going to do something for her. But otherwise, she has no use for us, including her dad. She never called me dad or father. She lived with us for 25 years. And the only thing she ever paid for was, I think it was 2, but it might have been 3 years that she paid for our propane for 8 months.
We have to focus on why the PPO is not required anymore.
First place, as soon as I got called in here by you or by her because I made 2 phone calls to Ruth because the PPO said, don't call your wife, don't call your daughter unless it's extremely important. Okay, the best friend we've ever had for 50 years died, and I called Ruth, and she, of course, she's never answered her phone, never called me back. And I said, Rick Clemens has passed away. He was in Jackson, or no, in Kalamazoo. And I said, as soon as I find out when his funeral is and where it is, I will call you back and tell you that. Okay, and then exactly 1 week later, my 90-year-old brother passed away. And my wife really liked Art, my brother Art. And so I called Ruth again and said, my brother has passed away. Uncle Art has passed away. As soon as I find out when and where the funeral is, I'll call you back. This was after the PPOs, okay? So for 2 telephone calls, you told me I was going to get 95 days in jail if I ever called them again, as long as I lived. As long as I lived. I figured that, and so I deleted their phone numbers from my phone so that I wouldn't bug dial them. Because I didn't want to get in trouble. The closest I've been to Bay City in the last 2 years was this summer. I was in Sebring for a bit of a life. I can't think what to call it, for Lou Tibbetts, who passed away. He was a good friend of mine. He was a neighbor for years. And I worked there at the camp for almost 20 years. Volunteer. I'm a Christian. And I try to do whatever I can to help people out. Whether it's churches or what, you can go to any church that I've ever gone to and you're not going to find anybody that says I'm mean or that I'm vindictive. I would never try to hurt my daughter or my wife or any other living being. She said I pointed a gun at my wife. No, I taught my wife how to hunt, and she had shot deer with a bow and arrow. Or a muzzleloader. She shot them with that and with that other thing. So no, I don't point guns at people. I've taught countless nieces and nephews and grandchildren how to hunt. And I teach them to hunt safely and don't aim the gun at anybody. So now, why would I want to shoot her? In the first place, with these PPOs, I can't hunt anymore. This year was the first year I haven't hunted since I was 12 years old. I started hunting pheasants at 12. So I'm a hunter and a fisherman. I'm an outdoorsman. And I like people. They'll tell you what. It's Beachy, Mrs. Beachy will tell you that. I don't know if you know Beth Ann or not, but she's in my state. Getting a bride, my nephew, if he hadn't had things to do, and
Well, we can't comment about people that are not testifying here in court.
okay.
The court didn't hear your testimony. No, don't be sorry. You're not an attorney. I appreciate that, but I understand. Is there anything else you wanted to add before I go back to Ms. Osborne, because it's her burden of proof?
No, the only thing I want to add is I don't want to have those PPOs against me. Can I tell you one more thing?
I said if there's anything else other than what,
Yeah.
it has to be admissible. Go ahead.
Okay. When I went to court, I had no lawyer. I had one, but the judge took him away from me and made him an advisor to all of us.
Would that have been Mr. Morosky?
Yeah. So he never ever did say, never said a word. You know, all those times we were in court 4 or 5 times. The other thing is, during the first time, which the judge gave me that, he had never even seen what I looked like, and he gave me this thing, said, "You're guilty. You're guilty." I said, "Okay." And Mr. Morosky said, "Come out in the hall, Bill, I want to talk to you." That's when he told me, "I'm not your lawyer, I'm an advisor for your whole family." And I think that was a ploy, because Judge Harrington said, "Now, Ruth, you have to allow your mother and dad to have meetings. You can have police there, whatever you want to do, but you gotta let them have meetings often." And she said, "Oh, no, Your Honor. Mom doesn't ever want to see dad again." Then during that same time, which she called me 5 times, and she said, "Bill, find a way to get me back home. Ruth is treating me like a prisoner. She tells me when to go to bed, when to get up, what to wear, what to eat, who to talk to on the phone, and then she listens in on all of those." So she had nothing to think of herself, because Ruth told her what a rotten person I was. But she called me 5 times before those PPOs were issued on November 6th. Told me she wanted to come home. And I said, "I can't. I've got a judgment against me in Huron County. Do you think they're going to change that?" I said, "If you want to come home, you call 911 because you're in Bay City. You get a police officer out there and you tell them that you want to go to court down here because you want to come home." I couldn't do anything else as far as I knew.
Ms. Osborne, your final argument.
Your Honor, there's so much to address here. Just about everything that Mr. Osborne said, Your Honor, was partial truth, partial not. Whether he's intending to say the things being untruthful or not, I couldn't really say. I think it's just a matter of confusion more than anything, Your Honor. For instance, what he just said about that Mom called him before the PPOs, and then he right after that says, "But then I had to tell her she couldn't call me because I can't do anything about it because I have a judgment against me," which is the PPOs. So he's saying she called before the PPOs, but then he's saying that, "Oh, I can't respond to that because I have this PPO." So he's confused about the timing on so many things and so many things. Is it okay for me to address all of those, or can I just address a couple of those? What would you prefer, Your Honor?
It's not my case.
Yes, Your Honor.
Presiding
Okay.
over.
Well, then
I
I will.
can't tell you, I can't
Yes, Your Honor.
render legal advice, but actually I think I'm ready to render it.
Okay. Thank you. The only thing I'd like to add then, Your Honor, is that Mr. Osborne's biggest point today is that he's not angry, and everybody knows it, or he's trying to present that as the truth. However, there are enough in-court statements that have been made by him, and so and Judge Harrington has seen him in his extremely angry state multiple times, to the point where he has said that it would be in benefit of a guardian. So, I mean, if we're looking at just trying to talk about character and anger and those kinds of things, I'm sure that Mr. Osborne probably could have even come up with more than 3 people in this county to come talk to him, talk about his character. But having been kicked out of multiple churches in the area due to his anger, I just
So
don't.
wait, that was not presented in that,
Okay, yes, Your Honor.
so the court will not consider that.
Thank you, Your Honor. But I definitely have police reports that put the lie to most of the things that he said, especially having to do with the gun incident and other things. So, Your Honor, I know you've seen a lot of things through the paperwork. And I guess I don't have anything else to say. Thank you, Your Honor.
May I say something?
No, sir, it's her burden of proof, so.
Okay.
So I'm going to proceed, no disrespect. At the conclusion of the hearing, the court must state the reasons for the court either granting extension or denying the personal protection order that's pursuant to MCR 3.705B6. Also, it's considered under statute MCL 600.2950(7) and A7. So if the court is denying the petition, the court must also immediately state the reasons on the record or in writing. Personal protection order was originally ordered on November 6, 2023. And the court heard the testimony. Actually, that was ex parte order. There was a request to deny that or to terminate that provision. Court had the hearing and the court continued the personal protection order. The court has reviewed as well and taken judicial notice of other court records. That is file number 23-42886CA. And that is a hearing before the probate judge, the Honorable David B. Harrington. Court reviewed the transcript. And Judge Harrington in his argument, and this was again, a little over a year ago, I would add that Mr. Osborne does not seem to fully understand the nature of these proceedings. I'm not attempting to make medical diagnoses, but having done many of these types of hearings, it's clear to me when people are understanding why they are here and what's being requested, and Mr. Osborne has confused the chronology of the events. I think Mr. Osborne is confused to a significant portion of the time, but he clearly has anger and anxiety issues for which he's treating. But it seems to me that he may well be in need of a guardian, but be that as it may. He completed it by on page 21, because you have these extreme anger issues toward your daughter. And then Mr. Osborne responds, well, I do, I'm sorry, I do. And so the court takes judicial notice of that. There has to be a reason to extend a personal protection order. The court has heard the respective reasonings of the petitioners in this case. The court has heard the responses from the respondent as well as the witnesses. The second witness, the court heard the testimony, and the court accepts his testimony. The court also accepts the testimony of Mr. Shemerick, and I will state for the record that I know Mr. Shemerick very well. He was my English teacher. He was my Spanish teacher at North Huron, and I highly respect him. I respect his opinion. I respect him as a human being. And it's not a voting year, Mr. Shemerick, either, so I'm not stating it that. But I'm stating it that I have a lot of respect for Mr. Shemerick. And when I heard his testimony, it just renewed that respect, because when he said, I've never seen Mr. Osborne act that way, to what I'm privy to, is in essence what he stated.
Yeah.
And I have no reason to dispute that as well. But then there is the old Paul Harvey saying, and now the rest of the story. What we have 2 distinguished gentlemen coming in and testifying, saying that Mr. Osborne's a good man. No question about that. I'm not going to deny that. I'm not going to say it's not true. It is true. Their testimony, they swore their oath to tell the truth. There's another component to this, though. That is the allegations that were made in the past and what's been going on in the future. Currently, up until the time of this request for extension, this personal protection order is set to expire, I believe, on November 5th or 6th, I can't remember. And So when the court considers the statements of Ms. Osborne regarding her mother and the agitation, the upsetness, the reverting back to past behaviors of the Alzheimer's and all of that, and as well as Ms. Osborne's comments regarding this I wouldn't say hatred, this essentially being afraid or concerned, not only on behalf of her mother, of herself, and let's be honest, Ms. Osborne is a former state trooper. Yeah, clearly she could take care of herself. I wouldn't want to be breaking into her home, you know, and I could do something. And I'm not making light of it, but it's true. I know she could protect herself, but that's not the point. The point is it necessary and is it required? And there is another side to this. There is the concern and even the interaction today, even though it may have been innocent on one side of the story, it's not on the other side. There's deep concerns of, I wouldn't say retribution, but a situation where it's clearly uncomfortable, not only uncomfortable, but to the point of where they have to take additional steps to protect in the event the situation arises. I find at this point that personal protection orders are appropriate. They are going to continue. They will be extended for another year, which would be November 1st, 2025. But my question though is those are no longer addresses required, correct?
Those, Your Honor, those are the churches that we attend.
Oh.
And I requested that because.
Okay, I wasn't sure. I didn't know that. So you're requesting.
I'm requesting that continues as well, please.
Prior orders will continue as previously stated. Be extended.
Thank you, Your Honor.
Can I say something?
Go ahead.
One thing that Ms. Judge Harrington never told you is he got memos from Dr. Nazarala, who said you got 30 out of 31. You are remembering things from back when you were 4 years old when you went to Florida. And Dr.
Well,
Schleicher,
Mr. Osborne, I have to stop you. It was not admitted into evidence.
yes, it should have been.
Well, it's not in the court record. I have what's before me right now.
He got it. Judge Harrington got those, because I know, because I talked to Dr. Nazarala and Dr. Schleicher, who was a neurologist and psychologist. And he patted me on the back when he was through with the 4 hours of testing. And he said, you can't lose. You just make sure you've got a lawyer.
Well, I'm not citing the medical issues. I'm citing the anger issues.
But your other judge is. He's talking about, oh, I think he needs to have looked after. You know what my IQ is? 197.
Well, I'm not questioning your IQ or anything. I'm only addressing the issue regarding allegations of anger. That's it.
Do I look angry now?
No one looks angry when they're in the courtroom. No disrespect. It's not funny. It's not funny. This is a professional courtroom. And when individuals come before the court on criminal proceedings, for example, they don't act the way they did when law enforcement made contact with them. They act a lot differently in front of a judge because they want to at least show that there's another side to the story. And I'm not questioning, Mr. Osborne, your intelligence. I'm not questioning your memory. There is an anger issue that I think is still deep and relevant. And as a result, I'm continuing the personal protection order over the objection. I appreciate it. Thank you. That'll be all. Off the record, Ms. Osborne, you and your client, or you and your mother shall leave first. As soon as the floor is cleared, then Mr. Osborne.
Thank you, Your Honor.
Just for a minute. Kara Marie Goki versus Brian Guilford Adams. It's a motion regarding support, taxes, medical decisions. Parties are present. Mr. Adams appears by the Zoom application. Ms. Goki appears in person. Will both parties please raise their right hands?
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
Yes.
I'm sorry.
Yes.
Report from the front of the court, please.
On August fifth of 2022, an order of support entered. That order granted the parties joint legal custody of the minor child and granted Ms. Goldie physical custody. Subsequently, a parenting time order entered on September 13th of 2023. That order granted Mr. Adams parenting time from Friday until Sunday on the first, third, and fourth weekends of each month during the school year, as well as weekly parenting time during the summer, break from school, and alternate weekends pursuant to the Friends of the Work policy. These are Mr. Adams' motions today regarding a number of issues.
All right. Mr. Adams, where do you wish to begin? The motion for support?
Yes, Your Honor.
Go ahead.
Okay, well, I have an opening if I could do that.
Go ahead.
Okay, since 2022, I have sold off a lot of my assets and taken on significant debt to cover legal fees, child support as a part of my ongoing effort to gain custody of my daughter. She has been exposed to difficult and damaging experiences, including environments with substance abuse, and unfortunately, she is now involved with these substances herself. I have reached out to Child Protective Services, the Michigan State Police, friend of the court, providing them with substantial evidence of my concerns. Yet, despite my efforts, I continue to have very limited contact with her. Over time, my daughter has grown.
With the child, correct?
Yes, sir. Yeah.
Okay, go ahead.
Over time, my daughter has grown increasingly distant, influenced by her mother's lifestyle, which includes substance use, inconsistent attendance, and general lack of structure and stability. Additionally, she has been alienated from me, and I have deep concerns about her well-being. As you can see from the medical records provided, her mother is an alcoholic, and they have a very strained relationship. I believe her environment is the primary reason for her mental health problems. I believe these issues can be addressed with counseling, and her mother believes drugs and substances are the solution. We disagree on this approach, so her mother keeps her away from me. The mother admitted to the doctor her own support of these substances, and this is documented in the medical report provided to the court. Her mother, who has few expenses due to her reliance on government food assistance, SSI benefits, as well as not having any rent or car payments, still receives the majority of my financial support for our daughter. I provide roughly about 85% of her support, yet I believe much of this goes towards party-focused lifestyles rather than meeting my daughter's essential needs. Financial burden of these payments combined with legal costs has also led to arrears in my child support. I respectfully request of the following: permission to claim my daughter as a dependent for the remaining years of her childhood, which would provide critical financial relief, better support my family while meeting my obligations to my daughter. And possible reduction of my child support obligation reflecting the financial strain I am under due to significant debt occurred in pursuit of my daughter's best interest. 3, consideration of appropriate consequences for her mother's repeated violations of this court's orders, which have contributed to my limited contact with my daughter and have impeded my ability to participate in her life. These adjustments would allow me to better meet both my daughter's needs and those of my household as I continue to prioritize her well-being and my family's well-being. End of statement, or opening statement.
Okay. And I appreciate you not mentioning the child's name. We will not mention the child's name, but let's cut to the chase here regarding the medical. The child is 15?
Yes, sir.
Okay. My understanding that a 15-year-old child has a medical marijuana card. Is that right?
Yes.
Yes, sir.
Is that correct?
That is correct.
Okay. As co-legal custodian, in other words, you have joint legal custody, what say did you have into this, Mr. Adams, regarding a medical marijuana card for a 15-year-old child?
Sir, I was never notified of this. I was never approached with this option. Basically, because I would have said no in a heartbeat. I don't agree with this. I had my daughter one time around Easter in April, and she showed me her medical marijuana card and even told me her mother told her not to tell me or show me, but she said that I have a right to
Well, I'm not going to go into what the child said. But
okay, sorry.
My question, though, has been answered. You state that you were never informed of this.
That is correct. That is correct.
Okay. Bob, what do you say about this?
That's helping her?
No. I want to know, did you consult with father having jointly? Why not?
I didn't feel I had to.
You have to under the law.
Okay.
You have joint legal custody. Now, I understand,
I've been
and this
taking care of
floors me, but apparently if you have 2 doctors sign on, that this can be obtained. Which doctors did you
I have two doctors.
Okay, were they local doctors?
I had one down in Warren and the other one was in Saginaw.
Warren and Saginaw. How many times has the child seen the doctor in Warren and how many times in Saginaw?
One.
One time.
Yeah.
Does the child have a treating physician
Yeah, she has yes, I have a family doctor for her.
locally? Has that doctor been consulted
Yes,
regarding this issue?
yes. So is her counselor. She's in counseling every 2 weeks.
Were you aware of the counseling, sir?
As of last year, I knew she was doing some counseling.
Okay. All right. Well, here's the problem right out of the gate. When I hear mom say that she didn't believe she needed to let you know of that, is troubling and it's wrong. When parties have joint legal custody, medical, religion, education, all those important decisions need to be discussed together. And a joint decision has to be reached. In the event that the parties cannot agree, you bring it before the court can address it at that point. And the court can do one of two things, either try and reach agreement with the parties, or if it goes to a custody hearing, the court may have an obligation to award one party legal custody because they can't work together. I'm really troubled. And this is just me, maybe I'm old school, but a 15-year-old carte blanche having a medical marijuana card, I have no words for it. I don't. Especially when one parent didn't inform the other parent of it. Now, we'll address the rest of that in a bit. The issue of taxes, mom has been claiming the child every year, correct?
Yes.
Okay, and obviously because you're the primary custodian.
Yes.
And it was never addressed by agreement in the original judgment.
No.
Okay, so there's a difference there. And on the issue of support, my understanding is, Mr. Adams, are you requesting a support review?
I believe I am, sir, yes.
Okay.
Based on her having a second job.
Okay, and I have a note here regarding the second employment. Do you still have that second employment?
Yes, I only work, actually I'm supposed to be at work now. I only work 3 hours a day. I had to take and get a second job because of the big payments I was getting for child support. Social Security literally took all my money away from me from February to June, so it put me in a financial problem. I have a van payment. I have bills that come in every month. I had to figure out something because I still owe money on my van. He's not supporting me. I support myself. I've been to support my daughter from the time she was born to until 23. And I don't get child support every month from him. So I have to figure everything out myself. I've been doing it by myself for years.
Do you have any questions regarding the second employment issue?
The benefits being cut off, I don't think I have any additional questions based on what she's given us.
Okay. All right, well, I have to make a decision regarding the tax issue. If it's agreed to in the form of a judgment, like we had in the previous hearing where they agreed regarding spousal support being non-modifiable, an agreement is an agreement, and the court has to enforce agreements. There are no agreements here. And as a result, under the federal code, federal bankruptcy code. The what code? IRS code. Bankruptcy is another story. On the IRS code, I stand corrected. Under the IRS code, the parent with the primary time gets to claim the deduction. As there's no agreement, I cannot grant the motion regarding taxes. However, I think the court can grant in the event that a party who will not receive a benefit for that particular year, then the other party can claim. I think the court can do that. Ms. Schultz, would you agree with that or not? In the event one party cannot claim.
I believe the court can include that language, so long as the parties both understand that if Ms. Golke, as the plaintiff entitled to claim the benefit, claims the benefit, there's going to be an issue with the court should it be claimed by the other parent without consent of the proper forms.
Right. So, and clearly Ms. Golke is working. She has even a second job. So I'm not going to order that, but I will order, respectfully, the request for tax deduction is denied. The issue of support based upon the information presented, the court will order a review of support by the friend of the court in this matter. All pertinent documentation, records, income information need to be provided to the friend of the court. How close to shows, other than Susan?
We'll request the information. I presume the court is intending to go retroactive to the date of filing, October 28th.
That's correct. Yep. Now, on the medical marijuana use. I was trying to research this so that I had a better understanding as to how the child even gets this material. I don't believe because she's underage, she cannot go into a dispensary, correct?
Yes, she can.
She can?
Yeah, card, yes.
She picks up her own?
They're on the medical side. And it's helping with her migraines or nauseation. I don't get phone calls from school every day from the pain medications, and it's monitored.
Who's it monitored by?
I monitor how much she gets.
You monitor?
Yeah. It's locked up and
This is a disaster.
you don't have access to it. Just as needed.
What does that mean, as needed?
Like for if she has a migraine or nauseation, because she's throwing up with her migraine is so bad, she's throwing up. And you don't want her on any medications or anything like that. So
Who doesn't want her on any medication?
he does not want her on any medications.
Well,
So he's putting like,
no disrespect, but technically speaking, marijuana is not a prescribed medication either. It's legal
it's
by the state of
natural.
Michigan. It's legal to be used, but you don't write a prescription for cannabis X amount of milligrams. You don't do that. Now, if it were Marinol in the form of a synthetic substance that is in pill form, that's another story. But what is this child taking? What type?
She just takes like 1 or 2 hits off the joint and that's it.
At 15. I know it's legal under the law. I get that, but we have a parent that did this without the permission of the other parent. I'm going to order that the marijuana stops immediately. I'm ordering that child be evaluated by the family doctor, all the information provided to the family doctor. The family doctor will then prepare a report to be provided to the court to be reviewed in camera to see what we need to do. I mean, I'm just picturing a 15-year-old taking I can't. This is crazy. I'm stopping it. The report from the doctor will indicate where we move forward. I also want reports from these other 2 doctors, one in Warren and Saginaw.
Yeah.
Are these the types of doctors where you find them online and you just meet with them and
So
go ahead, I'm sorry to interrupt you.
the one with the Saginaw, they go into, there's places where you can go to, get your medical card. And that's what they are.
So they specialize in
Yeah.
that.
Yeah.
So it's like one-stop shop. You just go in, hey, I need it. Okay, you need it, great, there you go, right?
No, they have a thing you have to fill out and everything and.
Okay. How long was the visit?
No, 20 minutes.
I'm sorry, I mean no disrespect to you, Ms. Goki, but this is, I've never seen this before. I don't want to stick my nose into medical decisions by medical professionals because I'm not a medical professional, but I just don't see. I need something more to indicate that this child needs something else other than proper medical treatment. A couple hits off of the joint can be abused so darn quickly. And this child has to go to school and function.
Well, here's a report card.
Oh, you can tell me she's doing well, and
She's got A's and B's and 1 C.
Okay,
She's doing really well. And her mental health's a lot better. She's doing great.
good.
She's not cutting herself no more.
Does she have a counselor?
Yes.
Okay, and that's right.
Yes.
And
She's doing good.
where does she go to counseling?
She was a Western Pigeon.
Okay, and is the counselor aware of her use of?
Yes.
I need a report from the counselor as well.
Okay.
But right now, I'm stopping it.
Okay.
And I mean no disrespect by it, but there's no control here or measure. Can the reports and documentation be provided within 30 days?
Yeah.
Okay, we're gonna schedule another hearing now in 30 days to see where we're at.
General, Ms. Hatch is looking for the next court date. Specifically, the court is looking for the providers to document the medical condition and any changes they've seen as a result of the marijuana use.
As well as the medical necessity for it. Yes. December 6th. Can you be here at 9 a.m. this?
What day is that?
It's a Friday.
Yeah, I could bump my schedule around like I did today.
What is your schedule usually on Friday?
Friday, supposed to be at work from 8:30 to 11:30 a.m. I only do 3-hour shifts. From Tuesdays, Thursdays, and Fridays, I work a 3-hour shift.
Okay.
And then my seasons changes a 6-hour shift on Mondays.
We're doing Friday. December 6th. I don't want to interfere with your work. Friday at 1:30.
Okay.
That'll take care of the work issue.
Yeah, yeah.
I want you to work.
She needs me.
Sir, can you be here via Zoom at 1:30? I know you're coming in from Rose City.
Yes, sir.
December 6th,
Number 6. What time?
1:30.
1:30.
And again, Ms. Goki, I'm not pointing at you directly on this regarding the law is a law, and I understand that, and I appreciate that, but without the other parent being involved, and at least my experience on the criminal side, when these medical marijuana cards are issued, a lot of times what will happen is people will just find some fly-by-night operation. In the past, we used to be dentists that would just, oh, you need a medical marijuana card, sign up, out the door you go. And that's what I'm concerned about. So if we get the proper documentation for Ms. P, we'll see Ms. Boyce speak before the court based upon a bench warrant that was issued for her arrest on April 12, 2024. She appears via the Zoom application currently lodged in the Huron County Jail. Ms. Boyce, would you please raise your right hand?
You solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God.
Yes, I do.
Thank you. You may put your hand down. Mr. Holder, can you tell the court what's happening?
Yes, Your Honor. Front of the court had sent a proof of service for a notice of a show cause. It was sent on March 11th, 2024 for a show cause scheduled for April 10th, 2024. That notice was sent to the city. No mail was returned. Ms. Boyce failed to appear to that hearing, and as a result, the court had issued a warrant for her arrest with a $700 bond. My understanding is that Ms. Boyce was picked up, I believe, yesterday, October 31st, and transported to the Tuscola County Jail on local charges in Tuscola County. She went before the judge yesterday, received a PR bond, and then was transported here on the front of the court warrant. I did have an opportunity to go speak with Ms. Boyce this morning at the jail. At that time, she did update her address with me in Saginaw. She did confirm that the 2 phone numbers that we had on file were no longer active. She did provide me with her new phone number. She did verify that the email addresses on file at the front of the court office are still valid. Regarding not showing up for that hearing, Your Honor, she did state her previous place of residence, I believe, was with her mother, and she was not receiving mail. Mail was either getting thrown out or not given to her. Nonetheless, she was not receiving mail. There were some issues in the home, and she had decided to find her own place and move out, which she states she did roughly 2 months ago or so. Currently, this case is charging $643 a month with an arrears of over $7,000. Speaking with Ms. Boyce, at this stage, she states she never got any notice of any court dates or anything along those lines. I did go over the file with her regarding motions for parenting time that she had pending before, that the court had adjourned to a date in July of 23, and then she had failed to appear for that, and as a result, her motion was dismissed. So we did discuss steps to take, move forward. She was requesting a support investigation or review with the front of the court office. I did instruct her on the steps she has to do to get that process started, and as well as requesting an audit on the account, and I did speak to her on how she can go about doing that. So currently, Your Honor, this, and last payment on this account was in December of 23. For that month, we received $97.23. Ms. Boyce states she is employed, but self-employed, cleaning houses, not going as well as she's hoped, but, here and there. She did give me a name of an individual to call regarding bond to maybe help her out. I did speak with this individual before coming into the court. He has been trying to come up with something to post bond for Ms. Boyce, but was not a guarantee. So that is the current status, Your Honor, at this point with Ms. Boyce. She did not update her address or phone number with us. When I asked her why, she said she just kind of lost faith in the court system with her involvement in the past with this file specifically.
It also helps to appear in court, though, required.
It does. She does not deny
Not her own
that.
motions.
Yeah, she does not deny that. She states when that had happened, she was misinformed, she misunderstood. She thought the motion was denied, so there wasn't a comeback. So she stated she had just misunderstood that one, and that's what that was. She did disclose that coming into the courtroom, just anxiety goes up, and sometimes she just can't remember or just can't think straightly when she's in the courtroom, which is understandable. I get it. But that's currently the status, Your Honor.
Okay. Thank you. Ms. Boyce, I'm going to come at you no confrontation here. There's no reason for that and no need for that, but you heard what Mr. Holwick stated, correct?
Which part?
All of it, what he stated so far this morning?
Yeah. Yes.
Okay. Do you have any reason to dispute any of that?
Just the part about losing faith in the court system. That's not why I did not come back. I thought that my motion was denied. I thought that my motion had been denied. So
Okay.
I didn't get anything else in the mail or anything saying that there was a new court date. So I did not come back.
Okay. Fair enough. But you understand, though, you're obligated to keep the friend of the court notified of any change of address or employment, correct?
I do now, yes, I understand.
And you were under a support order to pay, what is it?
Total, Your Honor, it's $640.
That can't be right. That cannot be right, Your Honor.
There's currently
I
it's
don't
charging
Wait, just a moment. Let me get from Mr. Holden.
Currently, there's two support orders, Your Honor. The first one is charging $294 a month to the defendant on this file for one of the children, and then it's charging $346 a month to a guardian of another child. The children are right now, and that's the most recent support orders. And as stated, Ms. Boyce had taken steps to try to have that changed in the past for motions. And then, as stated, there was that misunderstanding. She thought it was denied and didn't show up, and the motions were dismissed. But as a result of that, the previous motions have stayed in effect, which means it's continued to charge.
Right. Okay.
So, and as I stated, she's also was requesting a support review, which she would have to do once she is not incarcerated, and as well as requesting an audit on her account, which would have to happen after she is out of incarceration, which I did speak to her about that.
Right. You stated that a moment ago. So,
correct.
Bottom line, Ms. Boyce, based upon the information provided by Mr. Holdwick, you can file all that paperwork whenever you wish. You understand that?
Yes, I didn't realize it was even possible to have the audit done with him until he told me that I could.
Well, that's what
and I really need that done. So I'm going to get that paperwork rolling as soon as I possibly can. He's informed me that it would be a good decision to make new motions, file those for the last court hearing. That the last motions I filed, basically same ones, same thing, same process, and just keep waiting.
Well,
as far as work
of hearing provided, but let me get back to why you're here, though. You're here for the failure to appear back in April, as I understand it. But your last support payment was December of last year. I mean, just common sense wise, if you're not making a support payment, and
I cannot afford child support. I
get that. I get that. But you're obligated, if there is an issue, to contact the front of the court and or file a motion to address it. So frankly, how I see it is, no disrespect, but you ignored it. And that's why the bench warrant was issued. So is there any other explanation as to why you didn't appear at the court date, the scheduled date for Mr. Holdwick in April?
I did misunderstand. I thought that everything was denied, and I was just told to keep just filing new motions and I didn't know which way to turn. So I just thought that everything was what it was when I left that day. I can't even, I mean.
Well, I'm going to cut to the chase. I mean, you failed to appear, and whether that was by mistake, whatever it may be, I must find you in contempt. Mr. Holwick, do you have a recommendation?
I apologize. I'm sorry. I'm not trying to be a problem, and I do apologize, Your Honor. I'm sorry.
I am not taking it that way, Ms. Boyce, not at all.
You're speaking with Ms. Boyce at the jail, Your Honor. And of course, having her information updated with mailing address, email, phone number, which has been changed before we came to court today after I spoke with her. She stated she has maybe roughly $100 in her account right now that can go towards bond. This individual, she had given his name to me. Speaking to him, they're trying to come up with something for bond to help get her taken care of. In lieu of all that, Your Honor, I would probably state, and with what she's requesting as far as paperwork goes once she gets out, I would request that there be some form of jail sentence but held in abeyance. Give her a time frame to post something for bonds so she can work towards that or do what they have to do to make some type of payment to get this back on track. And then she can meet with our office to request her review, request her audit, get the motion form she needs to do, and to get those filed with the court to have another court date.
Okay. Ms. Boyce, do you have any comment in light of the comments made by Mr. Holdwick about how we resolve this?
Just that I would be able to come up with a payment plan for what I owe for right now until my paperwork is put through, until I can get something figured out where we can get to get this figured out. I would be able to I could commit to $100 a month, but that's all I can really commit to honestly right now, $100 a month for child support. And as far as a bond, I'm not.
Excuse me, we can't talk about the child support amount now. We're merely talking about the failure to appear, and there's a bond attached to that. So what I am going to do under the circumstances is, you said you could put $100. Do you have that $100 today?
Yes.
It's in your possession.
Yes, I do. I will empty my piggy bank, and I probably have $130. I probably have $130 altogether.
Well, we just took a bond that was 10% of the total amount, and this is in excess of 10%, because if the bond 643, $700 would be $70, would be 10%. You are to pay to the friend of the court today upon your release from the county jail $100. You are to meet with Mr. Holdwick and set up a time. If you can set it up today or whenever, that's fine. You're to set up an appointment with Mr. Holdwick regarding all the other issues that you have, to discuss the possibility of a payment plan. And what the court will do is hold 30 days of jail time in abeyance, which means that if you do everything you're supposed to do, I'll give you the 1-day credit. If you do everything you need to do, there's no jail time. But if you go off the radar, go off the grid, ignore it, whatever it may be, another bench warrant will be issued for your arrest, and then you'll serve not only the 29 days, but you could have additional time as well. So you don't have to serve any additional jail time so long as you make the $100 payment, make arrangements to pay the rest of the bond of $700, and meet with him regarding any issues or motions you wish to file. I mean, he can't provide legal advice, but he can at least give you information. And I think we should schedule this for another show cause. Would you agree, Mr. Holdwood?
I can, Your Honor. I can set it for next Friday with the court if the court wishes to have it with the court, or just a regular show cause date.
How about a regular show cause date with you, so long as everything works out?
When she comes to talk to me, we can look at dates that work and we can set that up.
Bench warrant will be recalled. You said you have something in your piggy bank. The $12 out of your piggy bank needs to be paid to the sheriff's office for their booking fee. When do you think you can pay that, Ms. Boyce?
Today. I will pay that today.
Okay. Sergeant Voss, if she's working today, we'll be sure she gets her $12 to the sheriff. the $100 today, payment plan, meet with Mr. Holdwick. As soon as the paperwork's received by the jail, we'll attempt to get that done as quickly as possible. That'll be signed, presented to the jail, you'll be released, bench warrant free call.
Your Honor, the one other matter is, the sheriff's department went to Tuscola to.
Oh, there's a transport fee.
Yes, if the court is asking that,
That's usually $50, isn't it?
it's usually $75. If the court is wishing, to make, you know, it is the $100. I know the court's done it in the past. If you took the 10% of 700 to the 70, if you did the 130 and a portion of that 130, or if you did made it 130, made a portion of the 130 for a transport fee. However, the court seems fit or deems fit.
Do you think you have $130?
I believe I should have almost $130, yeah.
Or if the court's ordering a transport fee and it just be paid.
And that's all I have until I pick up another cleaning job.
Transport
For
fees.
water, for food.
Ms. Boyce, I'm going to stop it right here. The
Yes.
transport will be paid within 60 days from today.
Okay.
That's $7. And again, failure to pay that, or you don't make arrangements to pay that, the jail time could be ordered. Because clearly you're able-bodied, you are working, I give you credit for that, but you'll be released today. 9DS. This is the plaintiff's motion regarding parenting time, as well as court and change of address. The petitioner, the plaintiff, is present, defendant is not present. A notice of hearing was provided on October 21st, 2024. And that was, there's a certificate of mailing from Alicia Thomas from the circuit court, or from the county clerk's office. For whatever reason, this matter did not end up on our docket. It was properly filed on October 21st. A notice of hearing was generated. And the plaintiff is here. Defendant is not here. The court spoke off the record to Ms. Sebra. She stated to the court that Mr. Epps and she had a conversation. He was aware of the hearing. He is not present today. He stated he would be here as well. He's not checked in via Zoom. He's clearly not here in person. And there's no excuse or justification that this matter should not have been on our docket. It should have been on our docket today, and it's not. I have a plaintiff here who filed the motion properly and is here, takes time out of her schedule. Defendant fails to appear. However, it's not even on our docket. And I can't explain it. You said, Ms. Sebra, let me place you under oath. Would you please raise your right hand?
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
Your name is Madison Sebra?
Yes.
And Ms. Sebra, what I stated a moment ago regarding our conversation before we went on the record, is that correct?
Yes.
Okay. Are you wishing to move? Is that what you're looking at?
No, I did move back to Huron County.
Okay.
I came from Hamtramck, now I'm back in Huron County. I'm at my mom's house in Utley right now, but my apartment should be ready in Badass. So I was asking the courts to renew our court order because of the distance. The parenting time, I need help with that because it's every other weekend right now. And that's difficult with no transportation for neither one of the parents, and being over 120 miles is hard with no transportation.
So when the judgment or the order was entered regarding parenting time in custody, was the child's address in Huron County or was it in Wayne County?
From the beginning of the court, it was in Huron County.
In Huron.
Yes.
And did that change so you moved from Huron County sometime to Wayne County?
Correct.
When did you do that? What year?
I want to say the end of 22.
Into 22. You don't work for Ford Motor Company.
No, he does.
He does.
Yes.
So the only time we had an order entered here was the last order would be September 28th, 22. It's called an ex parte motion to amend order of support. It is ordered that the defendant, namely Mr. Epps, shall be granted parenting time as mutually agreed until the defendant has a legal residence. Once the defendant provides a change of address in writing to the Huron County friend of the court and the plaintiff, parenting time shall commence as follows. Alternate weekends from Friday at noon to Sunday at 8 p.m., correct? Then there's some holiday provisions. At that time, when that order was entered, were you in Huron County?
I was.
Okay. So it was contemplated back then, when you were living in Huron, he was still living in Wayne, correct?
Correct.
And you were going to have the weekend parenting time.
Yes.
What is the change in circumstance warranting modifying?
Well, now he is in Melvindale, which is even further than where he was.
That's still Wayne County, though, correct?
I'm honestly not sure. But with him not having a vehicle and me not having a vehicle, it's hard, especially working with $300 a month in child support, to get her there and back halfway to MLA 4 times a month. I can't afford it. There's no way.
So you don't mind the parenting time continuing, it's just a matter of the transportation?
The transportation and possibly the time difference, I believe, because he seems to work on weekends now, and it's always, can you keep her an extra day? It's always something extra every single time. And I would never just send her, he doesn't have a babysitter, so I always keep her, but I just prefer the courts to recommend a whole new everything, so everything can be a certain way.
We really need you here. Are you currently working?
I did get a job yesterday, so I don't know the schedule. Thank you.
What is your work schedule?
I don't know. It's gonna be, I told them I'm able Monday through Friday 8 to 3. So it's gonna be around that.
What field of work are you getting into?
A restaurant.
Okay. I'll do next Friday. So we can be sure that it's on our dock. Deborah, we are going to renotice this and make sure that it's on our docket, and I apologize for that. Next Friday, and I'll schedule for 11 a.m. Can we do that? 11 a.m. You be here?
No problem.
Okay. That'll allow him extra travel time, or if he wishes to set it up via Zoom, that's going to be his responsibility. Provide him notice of it, and we'll address it. Again, I apologize. See you next Friday. This is the plaintiff's motion regarding change of address, support, parenting time. She is present in the courtroom. Mr. Epps, Demetrius Epps, is not. Matter was scheduled for 11 a.m. It's currently 11:13 according to the court's clock in the courtroom. This was scheduled last week, if I'm not mistaken, and there was a snafu regarding it being placed on the docket, and the court was very sorry about that. We addressed that, but time and date for hearing is now. Court inquired, actually, Ms. McName's deputy court administrator advised the court that Mr. Epps has not even checked in via Zoom. He is not present. Ms. Deborah, we will be proceeding. Would you please raise your right hand?
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
Thank you. Ms. Deborah, before I get to you, can I hear from the front of the court regarding the current status of this one? Schultz.
An order of support had entered on September 20th of 2022. That order granted the parties joint legal custody and granted Ms. Severo physical custody of the minor child. An order amending the order of support subsequently entered about a week later. And that order specified that Mr. Epps was granted parenting time on alternate weekends from Friday at noon until Sunday at 8 p.m., as well as alternate holidays pursuant to the 2022 credit court holiday schedule.
Okay, thank you. Ms. Deborah, what are you requesting?
I would like the courts to give me a recommendation for long distance. He has not seen my daughter since September 13th. He has not reached out to try
Of this
to,
year?
yes. He has not tried to reach out to get her, to see her. He doesn't even call the phone to talk. I was in the city, Wayne County, until October 10th. That's when I came back up to Huron County. So I was down there for a whole month, still never received him trying to come get her, nothing. And since I've been up here, he still has not tried. I do know of somebody that lives up here that has a long distance court order, and I feel like that would suit the best interest for the child. And then not just the parenting time for support, I feel like since he has not been having his parenting time or even trying to come get her, see her, I feel like $300 a month is not okay to be paying for his child when he hasn't even seen her.
How old is he now?
I believe 26 or 27.
No, is he?
Oh, the child, she will be 3 this month.
Prior to September 13th of this year, how often was father see the child?
He would definitely see her, yes, but it would be more or less, he has no way, so I would have to figure out a way if I wanted the break. If I didn't need the break or didn't want the break, he wasn't getting her because he never has a way. He has had to be a born over a year.
So when the parenting time was amended to Fridays from noon until Sunday at 8, he's not exercised that as previously ordered.
Maybe 4 out of 10 times.
Less than 50%, 40%. What is the change in circumstance that warrants modification of parenting time?
When I started the child support, I was 19. I was immature to the court. I didn't know what I was doing, honestly. So with that being said, it sounded great to me. But now that I'm back this far from him, and I see even when I was in the city, there was no help on his end, I see it's gonna be worse being this far away. So I would like the parenting time to change because of the fact that I haven't got no help from him trying to get her at all, unless I'm the one taking her to his actual house. Every time.
What is the support amount currently?
$300 a month.
And that's based upon the overnights he's supposed to be exercised.
Correct.
What is this motion for change of address?
Because I moved back to Huron County, so I was letting the courts know that I left Wayne County and I came back to Huron.
But this action was originally filed in Huron.
Correct. And then I moved back to Wayne County and we went to court for that. And I changed my address to the courts. So now that I'm back here, I just add that into my motion so you guys know.
And what was the reason for changing the address back to Huron? Wayne?
Housing situations, I can get more help out here for me and my daughter.
And you want the long distance parenting time policy?
Yes.
Schultz, do you have any comment about this?
Generally, I respect what parents believe is in the child's best interest in terms of parenting time schedule. However, our long distance parenting time policy is 8 solid weeks during the summer, and I don't know if that's in the best interest of the 3-year-old.
What say you about that?
I agree. I haven't ever been away from her for that long, so it definitely would have my mind wondering. But because his main excuse is I have to work, I have to work, I have to work. He doesn't have a babysitter. I don't think he's gonna even fully take her for the 8 weeks, honestly.
Can you stomach 8 weeks without the child?
I can, yes.
You think it's in the child's best interest?
No.
Okay, well, that answers that. Sometimes you have to be careful what you're asking. Okay. And I mean no disrespect by it. Failure to exercise parenting time is not a change in circumstance. As far as the court is concerned, or proper cause, but if it's support, it might be a little bit different.
If I may, Your Honor, we don't have a set parenting time schedule in place, as the court is well aware. But we do reference prior long distance policy generally in terms of speaking of what that may look like. But that doesn't mean that if the court was inclined to modify the parenting time based on geographical distance, I think the parties' residents do meet that threshold of more than 100 miles apart based on current address. And I think it may be more appropriate to look at having that summer session broken out in to 4 2-week segments based on the age of the child, and that would be a more appropriate parenting next step for a 3-year-old.
How do you feel about that?
I agree with that, yes.
And the long distance policy would also generally include one weekend, the second weekend of each month during the school year, September through May, and then alternate holidays, Christmas, Thanksgiving, spring break. Each parent would still be entitled to Mother's Day and Father's Day each year.
You agree with that?
I do.
Does that mean support has to be recalculated?
There would be a change that would go on the.
Okay. Well, father had the opportunity to be here. He's failed to appear in this matter. He's not been exercising his parenting time. And normally, this court has always said, if you fail to exercise your parenting time, that's not a proper cause or change in circumstance. Frankly, it's shame on the parent for not having the opportunity to spend quality time with their child. But based upon what I've heard at this point, mom is requesting, first change of address is granted. As the crow flies, it's clearly Hamtramck to, is it Bad Axe currently?
Correct. I'm at Ugly until the apartment is ready. Should be this.
So you only take about 8 miles off of that. That's going to be, as the crow flies, over 100 miles. Not by much, but it is. And court will adopt the long distance policy. However, the summertime is modified pursuant to the statements made by Ms. Schultz and adopted by mother in this case. Support has to be recalculated. Anything else, Ms. Schultz? Anything else?
I do have a question. Now, when it comes to taxes, because she did not mention taxes, she mentioned holidays, the summer, the school year. When it comes to taxes, it was agreed in the beginning that it could be every other year we switch. But with me having her over 300 days a year, I feel like I should be granted the taxes every year. I can give it to him this year because we did agree on that every other year, so that's no problem. But after this coming year, I would like to claim her for the rest of her 18 years.
Well, you're gonna have to file a motion for that.
That's a whole new motion?
It's a whole new motion. You didn't bring that in the original motion.
Okay, no problem.
Because the original order indicates that for purposes of taxes, plaintiff may claim the minor child during even numbered years, father not.
Okay, no problem.
So you'll have to file that motion, but otherwise the court will grant the relief that's requested. Good luck to you.
Thank you.